Dear students, in the previous lecture, I have discussed the brief history, purpose, and the composition of the International Court of Justice. Now, in today's lecture, I am going to explain the jurisdiction and the criticisms, challenges which International Court of Justice faces while with regard to its composition, jurisdiction, and operational dynamics. As you know, that International Court of Justice is the principal judicial organ of the United Nations. This court is responsible for settling legal disputes between states and also provides advisory opinions on legal questions referred to it by UN organs and specialized agencies. Understanding the jurisdiction of the ICJ is crucial for comprehending its role in the international legal order. The jurisdiction of the ICJ can be divided into three main types. The first type of ICJ's jurisdiction is contentious jurisdiction. It refers to the authority of the ICJ to hear disputes between states. There are two primary ways in which cases can come before the ICJ under contentious jurisdiction. First one is based on consent. It means that states must consent to the jurisdiction of the ICJ in order to proceed with the case. This consent can be given in various forms, like in the form of special agreements, which means that states can agree to submit a specific dispute to the ICJ through a special agreement, through a special compromise. For example, suppose country A and B are having a territorial dispute, and despite many attempts at the bilateral level, these two countries failed to reach at a resolution. In such a situation, country and country B may decide to conclude a special agreement or special compromise to submit their dispute to the ICJ for adjudication. The agreement would outline the specific issues which is going to be addressed, the legal arguments of the party, and the procedures for the ICJ's involvement. The ICJ would then proceed to hear the case, review the evidence presented by both parties, and render a judgment based on applicable principles of international law. Its decision would provide a binding resolution to the territorial dispute between country and country B. Second form in which consent can be given is treaty provisions. There are many treaties which contain clauses known as compromissory clauses, which automatically confer jurisdiction on the ICJ for disputes arising under the treaty. For example, consider the Convention on the Law of the Sea, which governs maritime rights and responsibilities among states. Article 287 of Convention on Law of the Sea allows parties to the convention to choose the ICJ as a mean of settling disputes concerning the interpretation or application of law. Suppose state X and state Y are parties to this convention, which is about law of the sea, and become involved in a disagreement over fishing rights in a maritime zone. So, state X and Y, by virtue of their membership of this sea law, have consented to the ICJ's jurisdiction over disputes arising under the convention. As a result, either state X or state Y can initiate proceedings before the ICJ to resolve their dispute under the treaty provisions. Another way in which cases can come before the ICJ under the contentious jurisdiction is states can take declarations under Article 36, Clause 2 of the ICJ statute, accepting the ICJ's compulsory jurisdiction in certain categories of cases. Take another example. Let's say state Z makes a declaration under Article 36, Clause 2 of the ICJ statute, accepting the compulsory jurisdiction of the ICJ for disputes concerning violations of treaties to which it is a party, as well as disputes concerning questions of international law. State Z's declaration specifies the categories of cases for which it accepts the ICJ's compulsory jurisdiction. So, if State Z enters into a treaty with State W and a dispute arises regarding the interpretation, regarding the application of that treaty, State W can bring the matter before the ICJ, invoking State Z's optional clause declaration. Despite State W's consent, State Z would be bound by its declaration to accept the ICJ's jurisdiction over the dispute. These examples highlight that how states can voluntarily submit to the ICJ's jurisdiction through special agreements, treaty provisions, or optional clause declarations. By doing so, states demonstrate their commitment to resolve disputes peacefully and in accordance with international law. Understanding these mechanisms is essential for us to know the practical applications of ICJ's contentious jurisdiction in resolving real world conflicts between states. Another jurisdiction which ICJ enjoys is compulsory jurisdiction. In limited circumstances, the ICJ has compulsory jurisdiction, which means that states are required to submit certain disputes to the ICJ for resolution. Compulsory jurisdiction mainly applies in two situations. The first situation is when states are parties to the statute of the ICJ. So it means that states have agreed to the compulsory jurisdiction in disputes arising under certain treaties or conventions. In other words, states may also be bound by treaty obligations to submit certain disputes to the ICJ for resolution. There are many international treaties which include clauses requiring parties to settle disputes arising under the treaty through the ICJ or other dispute resolution mechanisms. For example, the settlement mechanism under the United Nations Convention on the Law of the Sea requires parties to the convention to submit disputes concerning the interpretation or application of this treaty to the ICJ or the International Tribunal for the Law of the Sea for resolution. For instance, in the case concerning the maritime delimitation in the Black Sea, this was a case between Romania and Ukraine. The ICJ settled a dispute between Romania and Ukraine regarding their maritime boundaries in the Black Sea based on their obligations under the law of the sea. Another situation is optional clause. States that have made declarations under Article 36, Clause 2 of the ICJ statute accepting the ICJ's compulsory jurisdiction for certain categories of disputes may be subject to compulsory jurisdiction. In the case, for example, concerning military and paramilitary activities in and against Nicaragua. In this case, Nicaragua brought a case against the United States before the ICJ, alleging that the US violated international law by supporting armed groups in the Nicaragua. Nicaragua's acceptance of the ICJ's jurisdiction was based on the optional clause declaration deposed by the United States in 1946. So, dear students, we can say that compulsory jurisdiction of the ICJ arises either through states' voluntary acceptance of the court's jurisdiction via optional clause declarations or through treaty obligations requiring parties to submit certain disputes to the court. These mechanisms help to ensure peaceful resolution of international disputes and promote the rule of law in the international community. The next type of jurisdiction of the ICJ is adversary jurisdiction. The adversary jurisdiction of the International Court of Justice refers to its authority to provide legal opinions, to provide adversary opinions on questions of international law when requested by international organizations or United Nations organs. This means that the ICJ can provide non-binding opinions on legal questions. But these opinions of the ICJ do not have the force of law. These are not legally binding on the parties involved. But these opinions often carry significant weight in international legal discourse and can influence the behavior of states and international organizations. Let's take few examples with regard to this adversary jurisdiction. In 2008, the UN General Assembly requested an advisory opinion from the ICJ on the legality of Kosovo's declaration of independence from Serbia. The ICJ concluded that Kosovo's declaration of independence did not violate international law. While this opinion was non-binding, but it provided important guidance on the legal status of Kosovo in the international community. Another example is in 2003, the UN General Assembly requested an advisory opinion from the ICJ on the legal consequences of Israel's construction of a separation barrier in the occupied Palestine territory. The ICJ gave its opinion that the construction of the barrier violated international law and called for its removal. Again, though this opinion is non-binding, but it contributed to the international discourse on the Israeli-Palestinian conflict. Another example is in 1994, the UN General Assembly requested an opinion from the ICJ on the legality of the threat or use of nuclear weapons under international law. The ICJ gave its opinion that the threat or the use of nuclear weapons would generally be contrary to the principles of international law, but it did not definitely rule out their use under certain extreme circumstances for self defense. This opinion of ICJ helped to clarify the legal framework surrounding the nuclear weapons. These examples again demonstrate that how adversary jurisdiction of the ICJ allows it to provide legal guidance on complex issues of international law, which can help to clarify legal ambiguities and inform the actions of the states and international organizations. While these advisory opinions are not binding, but they are nonetheless helpful in shaping the development of international law, and they are also helpful in resolving disputes between states. So, in conclusion, we can say that the International Court of Justice plays an important role in the international legal order by offering mechanisms for resolving disputes between states and by providing advisory opinions on legal questions of global significance. Understanding the ICJ's jurisdiction, as I told you, is crucial to understand its functioning and its impact on the international law. Through its contentious jurisdiction, the ICJ adjudicates disputes between states based on their consent, treaty provisions, or optional clause declarations. Additionally, the ICJ has compulsory jurisdiction over certain disputes arising from treaty obligations or optional clause declarations to ensure that states uphold their commitment to peaceful dispute resolution and the rule of law. Furthermore, the ICJ's advisory jurisdiction allows it to provide non binding legal opinions on complex matters of international law, which can influence the behavior of states and international organizations and contribute to the development of international legal norms. So, overall, ICJ serves as a cornerstone of the international legal system, promoting the peaceful settlement of disputes, clarifying legal ambiguities, and promoting adherence to the principles of justice and the rule of law in the international community. There is no doubt that ICJ is doing good job and more work than its predecessor. It is now widely recognized that it has decided very important cases like cases relating to nuclear tests in France, Anglo Norwegian fisheries case, Indo Portuguese dispute, etc. It has also given many advisory opinions to the organs of the United Nations. So, though this court has contributed a lot to the international peace, yet there are defects in the ICJ. Like there is a problem with regard to the method of election of judges. There is no compulsory jurisdiction. Let us discuss some issues, some criticisms which ICJ faces. One common criticism of the ICJ is its limited jurisdiction, which relies on the consent of the parties involved in a dispute. This means that states must agree to submit their disputes to the ICJ voluntarily, which may prevent its ability to address certain contentious issues. For example, in the case of the United States withdrawal from compulsory jurisdiction in 1986, Nicaragua versus United States case. Nicaragua brought a case against the United States for alleged violence of international law including the use of force and support for paramilitary activities. However, the US objected to the ICJ's jurisdiction, leading to limitations in the court's ability to decide the dispute peacefully and fully. Another criticism is the lack of direct enforcement mechanism for ICJ's judgments. While the court's decisions are binding on the parties involved, there is no formal mechanism to ensure compliance, which can undermine the effectiveness of its rulings, its judgments. For example, in the case of the ICJ's ruling on the 2004 construction of a wall by Israel in the occupied Palestinian territory, the court declared the construction of the wall as illegal and called for its removal. However, compliance with the ruling has been very limited. Means Israel did not comply with the judgment of the ICJ. So it highlights the challenge of enforcement in the contentious geopolitical context. Some critics argue that the ICJ's decisions may be influenced by political considerations, therefore, leading to perceptions of biasness or inconsistency in its rulings. This could also undermine the court's credibility and impartiality. For example, in the Kosovo advisory opinion, the ICJ was asked to provide an opinion on the legality of Kosovo's unilateral declaration of independence from Serbia. The court's opinion was deeply divided, with some judges arguing that the Kosovo's declaration did not violate international law, while other judges disagreed with this opinion. This disagreement in opinion raised questions about the politicization of the court's decision making process. The ICJ's proceedings are also often criticized for their lack of accessibility and transparency, particularly regarding the availability of information and the participation of non state actors. For example, in many ICJ's cases, proceedings are conducted behind closed doors, with limited public access to hearings and documents. This lack of transparency can make it difficult for stakeholders to engage effectively with the court's work and outcomes. ICJ also faced criticism because its proceedings are lengthy and costly. So, lengthy and costly proceedings also challenges for states with limited resources and delaying the resolution of disputes. The case concerning the maritime delimitation in the Black Sea lasted for over a decade, with numerous rounds of written pleadings, oral hearings, and delays. The prolonged nature of the proceedings increased cost and resources for both parties involved, highlighting the challenges associated with complex international litigation. So, dear students, in today's lesson, we have seen the jurisdiction of the ICJ. And now we can say that while the International Court of Justice plays a critical role in the international legal system, it faces various criticisms and challenges that impact its effectiveness and credibility. Addressing these issues require efforts to enhance the court's jurisdiction, transparency, impartiality, accessibility, therefore, strengthen its role in promoting international peace and justice. In our next lecture, we are going to discuss the role of International Court of Justice.